day, everyone. My name is Andrea Chmielewski-Bigazzi. I have the pleasure of being the coordinator of Privacy Rules. Above all, I have the pleasure of introducing to you a fantastic panel of experts coming from different fields of expertise. But first and foremost, actually, let me thank Ivan Ivanov, the colleagues of Ubicon, and all the others who have created this event and have invited us to be the co-host of it. Today in the panel, there will be two co-moderators, Gerd Sommers from Belgium, partner at the law firm Timelex, and Markus Myrberg from Finland, partner at the law firm Lexia. We have the pleasure of being together with us discussing from the European Union Commission side, Alisa Weckermann, who will say a few words introducing herself and which are her very delicate tasks in this moment in particular at the European Union Commission. Vic Harkness from the global cybersecurity company F-Secure. She's speaking with us from London in particular, and she will explain also which are her tasks within F-Secure. And Privacy Rules member from India, Stephen Matthias, who is very important for his presence here because, of course, what we are going to discuss today has global implications and not only implications at the European Union level or within the European Union continent. A few words of about the alliance that I have the pleasure of representing here. Privacy Rules was launched about 2.5 years ago. Is a global alliance of legal but also tech experts dealing with anything relating to data protection, privacy, and cybersecurity. We are present in 52 jurisdictions worldwide, and we are growing by the weeks passing. Our scope is fundamentally the one of providing 360 degrees assistance to any company, organization, institution who has a problem related to privacy, or in any case wants to comply with privacy and secure its networks and its operations. I don't want to take much of your time because the real protagonists are all our panelists. I just would like to mention that we have another panel tomorrow for the Americas, again at noon Pacific daytime, and that panel will be dedicated to artificial intelligence, innovation, and privacy. In general, if you want to follow the activities of Privacy Rules, please visit our website that you can see here under my ugly face. And please subscribe to our newsletter and to our social media in order to have constant update. Thank you very much for the moment. Thank you very much again for the organizers of the Digital Week Online. And I immediately pass the floor to Markus in particular, who will make a presentation and an introduction of the core topic of today. Thank you very much again.
Thank you, Andrea. And it's a great pleasure to be here and attending and co-moderating this excellent session on international data transfers, especially personal data. And we will discuss around the subject matter, mostly arising from the EU Court's decision called Schrems II, and regarding the privacy shield mechanism and other challenges now facing the digital industry when regarding the international data transfers in the digital world, especially. Before getting into details and discussions and questions, I'd just like shortly to say a few words about the background. We're not sure that everybody's aware what was the background in these decisions and why we are today discussing this matter, especially today regarding EU and US, between EU and US, but only on the global level, at the global level. Sharing a short presentation on this matter at the same time. So, and here we go. And just a few words about how we came here and what has happened on the way. And of course, Before that, I just want to say that it's of course why we're discussing, because we're discussing about the importance, or that we know everybody the role of data nowadays, and data transfer, and it's increasing, and it has a very specific role in the global digital economy, and it's valuable. And part of all these data transfers or data questions is personal data, which is under various data protection regulations globally. Today we focus on certain of those, but of course this is not only a EU-US problem, but also in a problem and challenge sometimes all over the world sometimes, or problem or something to take into account. Background here, of course, in the EU, we do have a general data protection regulation nowadays, GDPR, which covers the international data transfers. Data transfers are as such covered already since the 90s, so this is nothing new, but of course some new mechanism and something to be more careful under the GDPR. Regarding the US, we have some challenges there. In the US, there is no this kind of general data protection regulation. It's more area specific or some industry specific, and there are some surveillance laws and actions available which do not comply with the GDPR and the privacy levels in the EU at this stage. I won't go too much into detail from the US point of view or the US legislation, just few backgrounds when we're talking about from the EU's perspective. And behind all this is, of course, that under the GDPR, it's the transfer mechanisms are controlled, and you have to do, if you're transferring data out of the EU/EEA, which the Commission has not adapted what we call adequacy decision, so safe enough country. So then you have to take some additional measures. There are some measures available, and you have to use, of course, the right one. The one, of course, always under GDPR is that you can ask for the consent, but as we know, asking for a specific consent regarding transfers, for example, it's not practical, and it's even not possible always. Then you have some other specific safeguard mechanism, what we call, for example, what we call standard contractual clauses. It's a standard agreement between the data exporter and data importer, and which has been accepted and given by the EU Commission. And then you have some other mechanism at more like governmental level, where, for example, we had a mechanism called Privacy Shield between the EU and the US. And Privacy Shield is a kind of self-regulatory protection system, and before Privacy Shield we had what they called Safe Harbor, but now we are facing the question that there are new rulings in the EU saying that actually the Privacy Shield is invalid. As such, we can't trust that as the mechanism between the transferring parties in the EU and in the US, and that's why something else has to be done. And there we go for the other possible solutions, which I already mentioned, and available we have, for example, what they call the standard contractual clauses. We talk today about SCCs, and they are still valid and available, but actually, according to the court decision, it was noticed that actually something additional safeguards have to use or depends a little bit the case, but maybe in general, you have to take some additional safeguards regarding the transfers, and that has caused also some practical problems. What to do in reality? What do I have to do? What do I have to require from the data importer and or the service provider in the US or somewhere else? And what should actions and contractual actions should be taken? There are some other options available under the GDPR, like what we call binding corporate rules, BCRs, but they are more like intra-group type of mechanism, and it's not always so practical to take into use. And as we discussed a little bit about the problems of consent. And there we come to questions, actually, what to do now. And so there has been some mechanism and there are some tools, but the overall situation regarding especially the transfers between the US and EU, which were based on the Privacy Shield, which is now invalid. So something has to be done there anyway if you trusted on Privacy Shield. And some challenges and questions regarding the SCCs also, so what to do in practice. And now I would like Gert to continue from here on, but before letting Gert to take the floor or take the online actually, so I just want to once say that if we talk from the perspective of the EU, it's not only the US, it's all a global question, and it's actually a good question how EU data is handled in the global digital world.
Indeed.
Please.
Thank you, Marcus, for explaining the basics of the legal challenges that we are facing today when transferring personal data at an international level. You rightly said we are facing a problem. We had solutions. These solutions are now under pressure. The Privacy Shield is invalid. The standard contractual clauses are valid under conditions. So, and it's not only an EU-USA problem, as you rightly said. I think we can conclude that there is a lot of legal uncertainty, growing uncertainty around these international data transfers. Also because the European Court of Justice said that there won't be a grace period after the judgment. So a lot of companies and sector organizations became very nervous and for the moment don't really know what to do. Even the data protection supervisory authorities in Europe seem to have, like doubts themselves, and there is also some uncertainty on their behalf. So it's really a complicated problem. And I would also like to add to that currently this is a problem from an EU perspective, but what if other countries around the world start adopting similar protection mechanisms for the transfer of personal data to the EU or to other countries around the world? It's even going to become a bigger mess. So we should probably also take that into account. And well, to go back maybe, as you said, this already exists since the 90s, but it was maybe differently enforced. We didn't have the GDPR yet. For many years, we took data transfers, whether it be personal data or confidential business data, kind of for granted. Just like we could travel across borders, data would travel across borders. And it was enough to have some formal documents such as the standard contractual clauses or the Privacy Shield to offer protection to those transfers once they are abroad. And the big question now is, do we have to stop sending personal data to other countries? I think there is an interesting parallel to draw maybe with the coronavirus, because that's also something we try to stop now at national borders, but it's very difficult to do so. The virus wants to go across borders. Personal data also do that. It's very difficult to prevent them from totally stopping crossing the borders. But we can, of course, restrict and put some modalities on these transfers of data. But how do we do that? Is probably by rethinking the transfers. I think companies are now, what they have to do is keep on doing business globally, but when they transfer personal data, ask themselves the questions: do we really need to transfer the data? And how can we provide certain protection? Do we have to start encrypting data? Yes or no? This will be a question more for Vic later, for example, from a more technical perspective. What we also see is that jurisdictions around the world see data more and more as a critical asset, and they want to keep the data within their borders. So we do also see more and more companies trying to keep data within the boundaries of the country, also because it offers more, let's say, protection against these legal challenges, but that's not always possible. Voilà, I think that this is in a nutshell, as a summary, what I want to say from my side before I give the floor to the European Commission. Well, and not only, also to Vic and Stefan, because this is a debate that needs to be had at the global level, and not only by lawyers, but also by technical people, by people from the institutions at policy level, regulatory, so from the various perspectives, because otherwise it's not possible. We need to find a balance between business interests and interests for legal protection. That's very clear. So, Alisa, I have a question for you. Of course, I would like to know what the viewpoint is of the European Commission after the Schrems II judgment with regards to compliance for companies in the EU when they transfer data. Should they be more careful when using the standard contractual clauses now? Should they put in place additional safeguards? How far should they go in assessing the laws of another country? And another question I will have for you is whether the new standard contractual clauses do take into account already these additional safeguards.
Yes, thank you very much. First of all, thank you. Hello to everyone. Just to maybe briefly introduce myself, as Andrea already mentioned, so I work indeed for the European Commission. I work in the Directorate General Justice and Consumers in the unit that deals with international data flows and protection. And so there I'm in particular working on different things, on adequacy, but also on the standard contractual clauses, which I'm sure we will discuss in detail today, and also on the follow-up to the Schrems II judgment. So in response to the question of Geert on what this means now in practice, what is required from companies, indeed it was already explained what the judgment is about. In the Schrems II case, the court pronounced itself on two instruments that were widely used or are widely used by companies to transfer data to the US, but also more generally to the rest of the world. The court indeed invalidated the EU-US Privacy Shield, so that of course is no longer a valid tool, can no longer be used to transfer personal data to the US. And the court at the same time also confirmed the validity of the standard contractual clauses, which are actually the most used tool in practice by European companies to transfer data internationally. So the court confirmed the validity, but then at the same time, indeed, further clarified under which strict conditions these standard contractual clauses can be used. One thing I think is important to mention here is that, of course, the case was about standard contractual clauses, the so-called SCCs, but the standard that has been set by the court, of course, applies across the board to all instruments providing for what we call appropriate safeguards. So also, for example, for the binding corporate rules that were mentioned earlier today. And the clarifications from the court essentially, so it requires that basically the data exporters and importers have to check whether in practice the data importer in the third country will be able to comply with its commitments under the SCCs or another tool that is used to provide for data protection safeguards. And according to the court, this includes checking whether there is anything in the legal framework of the third country of destination that might prevent the data importer from complying with its obligations under the chosen transfer tool. So in practice, what this means is that companies have to look at the specific circumstances of their transfers. So what type of data are they transferring? What type of recipient are they transferring to? What is the purpose of the processing? Who is involved in the processing chain? What is the country of destination? and see whether there is anything that would prevent the data importer from complying with its obligations following from the national law in the third country. And this could include, because that's what the case, that is what the case was about, the Schrems II case. This could include rules that govern how public authorities in the third country access the data once it's transferred there, for example, criminal law enforcement or national security reasons. And if companies come to the conclusion that there is indeed something preventing the data importer from complying with the obligations, then companies have to carry out an assessment of those rules in the third country, in essence, to check whether those requirements are limited to what is necessary and proportionate in democratic society. So that's especially relevant in this context of access by public authorities to the data. And if not, if they come to the conclusion that there is an issue in the third country, then companies have to look for and put in place what the court calls additional safeguards or supplementary measures to complement the SECs or another transfer tool to address that issue. And these can be of a different nature, can be organizational measures, other contractual measures, or technical measures. Indeed, encryption is often mentioned, and I'm sure we will discuss that in more detail as well. I don't want to go on too long because I know this is only the first question, but just to confirm that, of course, what was already said, what Geert mentioned, it is indeed a difficult assessment to make. I think everyone is aware of that. There is a lot of uncertainty at the moment, and we know that there's especially smaller companies that find it difficult to know where to start, how to do this assessment, and to really know concretely what to do now. So guidance on this is very important. The data protection authorities have started working on guidance. They already issued the first document, but they're now working on more detailed guidance. I can talk about that also a bit later, but just to say that I think indeed it's crucial that there will be more guidance, and there is a lot of work ongoing. And I agree that it is important to have a dialogue with different stakeholders on this, because I think on an issue like this, actually companies and the industry, they have a lot of experience with the type of measures. They know very well what type of data they're transferring to which destinations, what kind of measures they already have in place, or what kind of measures they could be feasible. So we are engaging a lot with stakeholders, and I think that is very useful, because our experience is that there is a lot to learn from existing best practices, for example, on the market. So I would agree that there is indeed, it is important to have this dialogue with the Commission, but also with the regulators, because I think this is something that also for the guidance and for our work on the standard contractual clauses, there is a lot of already practices that exist on the market that we can build on and that we can also use in this context. So I will maybe stop here because I probably already spoke too long, but happy to continue later.
No, thank you, Alisa. Excellent, and thank you for deepening a little bit the background and the basis, what's happened and what's needed to be done and needs to be done, etc. And we will come to the once again a little more the practical, not the practical, but some solutions of where to start or where to go, or what's happening next, probably in the end of this session. So just like it's summarizing also some takeaways for all companies in struggling with these problems. But now it's time to also involve Vic in the discussion. So, and before letting you introducing yourself shortly, and I would like to ask the question regarding, so a little bit more about the security questions probably, and about how EU residents actually could protect themselves from, when we talk about US-based platforms and when transferring the data to the US, and or kind of handling the data over to foreign authorities or under the control of foreign authorities. Please, Vic.
Hi. So I'm Vic Harkness. I'm a security consultant at F-Secure. I'm not by any stretch a legal expert, just interested in privacy, mainly from a technical perspective. But it seems like there's not really too much that an individual person can do one of the main criticisms I read about Privacy Shield was that there was no way for people to really, take ownership of their data. With frameworks like GDPR, people get some more control over their data, but still it seems quite hard for an individual user to regain control. So my kind of bit of general advice for people in the EU who are worried about other countries learning about them would be to lie more on the internet, perhaps controversial statement. But there's things like when you're registering to a website, you put in your username, you put in the password you want to use, and the website says to you, hey, can you give me your mother's maiden name? And we can use that as a security question to validate that it's you if you want to change your password later. There's no reason you have to actually give them your mother's maiden name. The answers to these security questions should probably be treated a bit more like they are passwords. So just give it like random letters and numbers. The computer doesn't know any different. You can use tools like password managers to kind of keep track of all of these like security answers that you're giving. And because you don't really want to be using the real data, because someone could just go on social media and find your parents on there and get your mother's maiden name and use that to reset your account. And likewise, if you're giving like the street you grew up on, your mother's maiden name, I don't know, other just random bits of information about yourself, it's potentially stuff that you don't want a foreign nation state to know about you. I'm not sure how much they can do with that information, really. I mean, I guess like the street you grew up on could be useful information, but generally you don't need to be handing over this data. I mean, the best way to protect yourself from the Schrems case came about because of Facebook's usage of data, but if you want to use services like Facebook, you kind of have to hand over your data, I guess. There's the idea that if you're not paying for the service, then you are the product. They are making a profit off of our personal data. But just consider if you really need to give your personal data to these companies so that you don't have to risk it being transferred internationally.
Thank you. And of course, this is also at the company level, kind of. So thinking about what data will be transferred and in which form, of course, in practice. So not, of course, at the end of the day, it's a question about private persons, but and data subjects. But the problem is also when companies and entities are transferring huge amounts of data, including personal data. But we will come back also this later. So thanks. Gerrit, please.
Thanks indeed, Vic. So I guess, we can draw a parallel between the need for transferring personal data at the personal level or at business level. That's very true. I just wanted to add to what I said before, that a lot of our clients came to us with questions, of course, after Schrems 2 in the past months. Whereas originally we advised our clients to, wait and take a waiting approach, let's say, and see what the guidance of the authorities would be over the next weeks and months. We are now being a bit more strict in our advice, and we are telling them that they should interpret this judgment quite strictly and exercise enough prudence. So really think, do we need to transfer? What can we already put in place? Should we, if we are, let's say, talking to business partners abroad, especially in the US, but not only, then to really actually even reconsider such business abroad, as long as there is not clearer guidance, because the consequences of the judgment, could be quite heavy. So it's not to be, let's say, underestimated. That's one thing I wanted to add to what I had said before. And then I maybe have a question for Stefan, because we said we would, look at this not only from a European legal perspective, but also from other jurisdictions. So Stefan, when we're talking about transfers from the EU to the US, could you tell us what has been going on in India after the Schrems 2 judgment, especially given also the huge amounts of personal data that are transferred to India from the EU?
Sure. Hi, everyone. Yeah, I think, we must understand the background here, which is that there is more data of the world that's processed in India than in any other country. And so this issue directly hits India in the sense of, can data of EU citizens be processed in India? India does not have a robust privacy law. There is one that is in draft stage, but it hasn't been passed by Parliament yet. And so the question of an adequacy ruling does not apply. So data is processed in India using the SEC route. Initially, there was some unease over this judgment and what it could mean for processing of personal data in India. One of the things to note is that a lot of the businesses that are processing data of EU citizens are essentially processors rather than controllers. I think controllers have a harder task because they are controlling the data, they have it in their country, whereas in India as a processor, there are more opportunities in terms of what to do. One of the things that I have found in my experience is that in the last few years, we've seen more of a rollback of data storage in India. And there is a far greater use of remote access to data from India to the country where the data is stored. A lot of the international companies, the banks, the financial institutions, and so on, overwhelmingly they use VDI or virtual data interface, which means the data may be accessed in India, but it's not actually transferred to India. It's not stored in India. So I think that affords some opportunities of protection. One of them is, of course, encryption. High levels of encryption means that a government authority would not be able to, access data through the access it has to telecom networks. And the second one is that possibly if the government were to show up at a business's site, then some form of notice requirement to the customer that there is a potential for government access and perhaps a way of pulling the plug. There are some obstruction of justice issues there where you know what the consequence is of that notice, and could it be considered as obstruction of justice and so on. But by and large, we feel that the way that data is processed in India, the way it's accessed in India, gives some opportunities for data to continue to be processed in India while still being compliant with this judgment.
Thank you very much, Stefan. That's actually indeed very interesting, and also the fact that there is an important distinction to be made between controllers and processors, of course, and that's also something that the European Commission is taking into account, and not only from controller to processors, but now also from processor to processors or sub-processors. This is something that at least I will probably be able to elaborate on later. Another concern I think that businesses will also have in Europe now is that while we are awaiting guidance from the various supervisory authorities, there is also a high risk of fragmentation between divisions, the interpretation and the enforcement of the Schrems II ruling within Europe. So this is probably going to create some additional uncertainty until we have guidance or more conclusive guidance from the European Data Protection Board. As a matter of fact, what's probably also interesting to mention is that just last week, on October 8th, so which was last Thursday, the French Data Protection Authority, the CNIL, found that European organizations have to stop storing health data on servers of American companies, even subsidiaries within the European Union, just because they're subsidiaries of these American companies, which is quite far-reaching decision if you think about it. Even if this data are stored on servers within the EU. So going back to the institutions, and I'm looking at you, Alisa. What is the European Commission doing now in response to the judgment? And for example, also, will there be a new privacy shield, or another adequacy framework for transfers to the USA? Are you considering similar frameworks for other jurisdictions or other regions in the world? Are you working on new adequacy decisions for certain countries, etc.? So what is your vision on how we can move forward, and how, from a policy perspective, you can, as much as possible, take away the concerns and help to find that balance between the legal concerns and the business concerns?
Yeah. So just one small clarification. Indeed, at this point, this case from the CNIL, what is also very interesting, I think, is that it was indeed a decision taken by the CNIL, but the Conseil d'État in France did not follow it and said that there was no reason at this point to suspend the processing in the EU because of the possible risk of access. So I think it also shows that, so here in Europe, even among institutions, there's still discussion on this and on how exactly to interpret all of this. Just as a side note, and now coming back to indeed to what the Commission is doing, for us, our priorities are essentially to ensure, of course, that personal data remains adequately protected when it's transferred abroad in full compliance with the judgment, but also that companies are provided with solid tools on which they can rely, because it is a reality, as we said earlier, transfers are taking place all the time for various reasons. It's part of the global economy. And we recognize that. And I think in terms of the protection of individuals, but also for legal certainty for companies, it is essential that they can rely on solid, sustainable instruments. And then a last priority for us is what he had mentioned, is to ensure consistency across the EU, that there is a consistent approach and a consistent response to this judgment. And so to support these priorities, we're working on different work streams. So to say, one of them is what was mentioned earlier, the modernization of the standard contractual clauses. So this is something that we started doing already months ago. It's work that we had to do regardless of the Schrems II judgment, because the existing clauses, they were adopted quite some time ago. They're not fully adapted to the GDPR, and they're not fully adapted to the modern business reality. So we are modernizing them, for example, indeed by including more scenarios. So not only controller to processor or controller to controller, but also processor to processor, processor to controller. And we're trying to make this a more business-friendly model, also, for example, by allowing companies to join the standard contractual clauses, to have various parties throughout the life cycle of the contract. And then, of course, now, following the Schrems II judgment, what we're doing now, because we're really at the end of this work, we're finalizing it and hoping to be able to share a draft of the new clauses in the coming weeks. After the judgment, what we're doing is we're trying to incorporate some of the clarifications provided by the court into the SCCs. So, for example, in terms of the assessment that companies have to do, this assessment of the circumstances of the transfer, giving certain elements that companies could take into account. So basically what we're trying to do is to provide a certain methodology within the SCCs that companies can use to help them in their compliance efforts. Also, types of measures in terms of additional safeguards that they could put in place. Of course, this will not be a magic solution, because we cannot be too prescriptive, but also the SCCs are a tool that can be used to transfer data to any country in the world. So necessarily, you still have to do this assessment. You still have to comply, of course, with the conditions set by the court. But we want to give some elements to help companies with this. I think it will be especially relevant for small and medium-sized companies, because the SCCs are a ready-made tool and are easy to implement. And of course, what we're doing on the SCCs, it's essential that all of this is fully aligned with what the data protection authorities are doing on the guidance that I mentioned, because all of this has to complement each other. So we're also working very closely with the European Data Protection Board on their guidance. In our view, this guidance needs to be as practical and concrete as possible to really help companies. And of course, it's important to ensure consistency, and it's also important to inform the enforcement action of the data protection authorities. We've seen there's already been quite a few complaints, and the first investigations are being launched. So also there, it's important to see a consistency across the EU. Maybe a last point, because you asked about the US and possible other adequacy decisions. Indeed, the Commission has initiated talks with the US. To explore the possibility of a new and improved data protection regulation. So this is something that we have been working on for quite some time. And it's something that we hope to be able to share with the US. So transatlantic data transfer framework. There is an understanding on both sides that adequacy or an adequacy decision remains the most comprehensive, the most solid tool. So we are ready to explore that. So right now there are discussions at technical level. Of course, these are not easy issues to resolve. It concerns an area of national security, which is already by its nature quite sensitive. And of course, in the US, we're in an election period, which also has an impact on the timing of how we can move forward. But we are ready to have talks at technical level. What should, of course, be clear is that we cannot have a quick fix. We need to have a solid solution that complies with all requirements of the court. Very briefly, because I realize that I'm again a bit long, but on other adequacy talks, indeed, of course, the standard set by the court in the Schrems II judgment does not only apply to the US, but to all, it's a standard in general for adequacy. So we're taking it into account in our ongoing adequacy talks with South Korea and the UK. And we're, of course, also taking it into account in our review or evaluation of the existing adequacy decisions, which is also something that we have to do under the GDPR. And I will stop there now.
No, I think that's very interesting. But personally, Alisa, I heard you say that companies have to make their own assessment. And I very much understand that on the one hand, you have the contractual relationship. So you're going to look at your importer based abroad and see, what type of company this is, what type of data you're transferring, what technical measures you may be applying, maybe restricting certain transfers because the data don't necessarily have to be transferred. That's one aspect which companies can keep under control. But then that other aspect, assessing the rules, the laws of another country, I personally have I'm very conflicted as to what extent companies should actually be doing that assessment themselves. So that I'm sure a lot are struggling with, because that's a very difficult and also very expensive task. And so I'm hoping that over time there will be, let's say, assessments of the laws of a certain country that companies can use, and say, okay, this is an assessment made by someone officially, and for that part we don't have to do it ourselves. So you said that in the standard contractual clauses you will give guidance and it will be as practical as possible. But for that part, it seems very difficult, because that's really country specific. Moreover, these laws in third countries can also evolve. So you would have to keep stay up to date with those laws, which is almost an impossible task. Do you agree?
Well, just to respond, because I don't want to take time from other speakers, but yeah, I mean, of course, it is a difficult task. I think everyone recognizes that. How exactly, I don't know, maybe this is something, of course, I think we all have to see, both the Commission and the data protection authorities, how this further evolves and how much guidance in the end, we'll be able to provide and maybe build on guidance. I think now the main thing is that the more detailed guidance comes out as soon as possible, giving more flesh to these different aspects that companies have to do, this assessment, what type of safeguards, these type of things. And there will already, I think the idea is already to provide a bit of more guidance on indeed how do you even start this assessment from the law in a third country. But further on, I think we will have to see whether there could be ways to further clarify this. It's a bit difficult to of course, we as the Commission, we do this in our adequacy talks, but cannot do this for the whole world. I don't think we would have to have a whole separate Director General only dealing with adequacy. I'm not sure this is also something that data protection authorities have to do. Also, because again, I wonder also whether it's really possible to have these abstract assessments of the laws, because it really depends on the circumstances of the transfer. And I think we also have to be a bit careful that with these more general assessments that we don't run into certain too black and white approach where we would almost blacklist certain countries and accept other countries. So I think we also have to be a bit careful of that approach, of avoiding that. But yes, in the SCCs, we will try to integrate different elements to help companies. And I hope that together with the guidance, this will already be a useful tool. But as I said, it's not going to be the magic solution. We have the standard set by the court, and yes, it has to be complied with. I just hope that with the SECs and this guidance, we can give already sufficient tools for companies to start this work. And then I think further guidance will probably come as all of this evolves. that would be my answer at the moment.
Great, thanks, Elisa. That's perfect, and I think that's already clarifying a lot. Maybe we should look again at Stefan. You know, from the Indian perspective, is there anything after all these explanations that you would like to add from the Indian regulatory perspective?
Sure. I think after the judgment came out, a lot of clients approached us, wanting to take a look at the Indian regulatory regime and how it stands up to EU standards. And I think the first issue was, what exactly should we be looking for? Is it purely just the issue of remedies of a foreigner under Indian law, or is it much more than that? So we came up with a few things that we should look at. The first one is fundamental rights to privacy itself. India had a very landmark judgment about 3 years ago, which stated that privacy, the right to privacy, is a fundamental right under the Indian Constitution. So that was good. We have to look at what kind of data is being assessed and whether that's personal data. What are the grounds of access? So our constitution actually provides the framework for that, and that is captured in the surveillance provisions. So essentially it covers things like security of the state and so on. So while those grounds are fairly broad, there are at least some grounds that are provided there. And in a judicial hearing, one would still need to satisfy the court that those grounds are being, justifiably used. The next one we looked at was, what is the procedure for access, and are there sufficient safeguards with regard to the procedure for access? So here, Indian law, by and large, there are two provisions, and both of them essentially require the senior most bureaucrat in the state or at the central government to certify that the request being made for surveillance is acceptable. So there is some procedure for access there. The next one would be judicial oversight, either before the fact or after the fact. Unfortunately, that's not there in India. The oversight here is by the the senior security bureaucrat in the Home Ministry. Interesting, there is actual judicial oversight in the US, and so India, it falls behind in that respect. And then finally, we looked at what is the remedy for access to this data, and do foreigners have a remedy as well? By and large, the answer is yes. The Indian law doesn't really distinguish between foreigners and Indians on this score, and it's mostly about using the inherent powers of a court to deliver justice. So overall, we felt that while there are some inadequacies in India compared to the EU, it's not a outright lost case. So we've been providing this kind of analysis to clients, and then clients have considered what they should do in this context.
Thank you, Stefan. This is very good advice, and of course, good to have all this work done at the regulatory level also. And it's good to hear that you are asked about what's the situation and have solutions, and actually quite situationified as far as I understand regarding the transfers and adequacy. But also we touch the regulatory level and the contractual level, but once again, then of course there is this like kind of more I would say practical and also at the same time technical points of view. And of course, here it's very important to act, for example, between the legal advisors and technical solution providers and technical experts. By this, I also refer one question to Vic, because of course, we're talking about personal data and personal transferring of that. But how about if we anonymize the personal data? it won't be personal data anymore, or will it? Can we do really at the safe level? And at the same time, of course, how about encrypting in overall? We touched a little bit encrypting here also already, but maybe these two questions from the technical point of view, please.
Yeah, so encryption's been brought up a couple times in this session as a potential solution to these issues. And I just kind of want to say that the use of encryption is not really a silver bullet that will protect all user data. Like, to be able to get the data back once to its unencrypted state, once it's been encrypted, you need a decryption key. And what's to stop the governments from compelling organizations to provide these decryption keys, allowing them to gain access to the unencrypted data? So for example, in the US, they've got this law that came in, I think it was 2018, it's fairly recent, called the Cloud Act. And this allows federal law enforcement to compel US-based technology companies to hand over data regardless of if the data is stored in the US or not. So if a US company's got offices in the EU that they're holding data at, they can just say, nope, give us that data, even though it's not on US soil. So say you were taking precautions such as adding contractual clauses that your data needs to be stored within Europe and that it needs to be encrypted. Yeah, it may still be possible that the third country government could gain access to it if they're the ones that hold the encryption key. Like anecdotally, I've heard that some companies have begun to use third-party companies to hold the encryption keys. So like there'll be a company in Europe that will encrypt the data and hold onto the key before it's then passed on to the third country company, such as one that's US-based. So that way, I guess the US government in this example would not be able to access the keys as they'd be held by a non-US company. So they'd have no right to demand that from that company. And I mean, aside from those issues, encryption's not always as well done as it could be. Many encryption algorithms, which are, in fairly common use in my role as a security consultant, I see them quite often. They've got some like minor vulnerabilities that are quite hard to exploit. I mean, like your standard hacker would have little chance with them. They're very difficult to exploit. But the massive amounts of resources that nation state level actors often have would allow them to exploit these vulnerabilities. So you might think your data is secure when in fact it's not at the national state level. So I would implore people to carefully consider the usage of encryption to try and secure data which is going to be held by non-EU based companies, just because your data might not be as secure as you think. So it was also raised that you could just anonymize the data. Like for some data-heavy businesses, it might be possible that the data could be anonymized before it's stored or being processed in a different country. So say you're running a dating website. It's something that's got a lot of personal information in it, right? So you want to keep that very secure. You've developed this kind of complex algorithm that can do all of the matchmaking that's required for dating websites, and you decide you're going to run it on a cloud-based provider. So you've got your user data, people register to your site, they hand over all their information. And before sending this user data off to be processed, you replace the user's name with a randomly generated number. So it's anonymized, right? But you're still sending a lot of data which could be used to identify a user. So, you've removed their exact address before you've sent it over, but because the dating site needs to match people with people who live near them, there's still a rough geographic area and the data of that's being transferred. And this person's provided a lot of other data about themselves. So like their gender, their age, their height, their political beliefs, how often they brush their teeth is a question that one site asks. So if you've already got some data on a given person, like, the rough area they live in, their gender, age, height, etc., you could use that information to try and match against the anonymized profile. And that's actually a principle that websites use to track users who aren't logged into websites across various websites. It's called like browser fingerprinting. They'll look at things like specifics of the computer that's accessing the site and some user behavior metrics to try and match you. Even though it's completely anonymized, they don't actually know who you are per se. They can just match you together. So, I mean, from here, if you can try and match this basic profile you've already got of a person to the highly sensitive but anonymized profile that's being stored on this dating site server ready to be processed, then you can gain a lot of information because, this person who joined the dating website, they wanted to find the best potential suitor possible, so they provided all kinds of data. So, in that scenario, you've got to kind of think about do you really want third country governments to know about your sexual preferences? There's all sorts of information that they could potentially gain access to in this scenario. The exact uses of it, I couldn't comment on, but you've really got to consider what you're putting on the internet. And even if the company is assuring users that they're anonymizing data, there's still workarounds for it. If they're saying that they're encrypting all of their data, it's possible they're not using the best encryption. It's possible that they've just, had the intern do the actual implementation, and there's, been some issues with it, so it's not as strong as it could be. It's a lot of trust that users will have to place on the companies to handle their data appropriately and secure it appropriately. And again, coming back to previous comments about there's not really too much that an individual user can do. They don't get too much legal recourse in this scenario, especially if the company did misuse their data. It seems like it's a bit of a bad situation for the individual user, really, at this point. So hopefully something comes out of the Schrems 2 cases that clears up the legal rights of the individual person and helps companies to protect their users a bit better.
Thank you. We could talk about anonymizing and non-identifiable data, or when is it and when it's not all the day. But I think, Gert, we should shoot the final questions first, maybe to Alisa, and then have quicker all around some comments.
Yeah, is there any particular questions from the audience? I don't believe so. We have two minutes left. So maybe we can do just more like a wrap up then of the session. Huh?
Yeah.
As main takeaways, I think from what I heard and learned is indeed that companies, organizations should take this seriously and should use, let's say, the Schrems 2 more as a symptomatic, something symptomatic that's happening in our world, where we have to exercise more care in general when transferring data, not only from a legal perspective, but as Vic rightly said, also from a technical perspective. We shouldn't be too naive and think, that by signing a document, standard contractual clauses, or by putting in place encryption measures, all is good and we're fine. No, this is part of the larger accountability principle that is key of the GDPR, where organizations have to do their homework. And it starts with, when the GDPR came up, the audits companies have to do, the measures they have to put in place to comply. And this is an ongoing exercise and process. This is about constantly asking yourself, what I'm doing, is this right or not? And as I said at some point, if you are now talking to new business partners in other parts of the world, you may want to ask yourself the question, should I really proceed or not? I'm not saying you shouldn't, but you should very much reconsider this and make sure that, as Alisa said, you exercise your due diligence on that provider abroad. It's really like, how you treat your own confidential business information. That's also how you should be treating personal data. That would be my take on that as a main takeaway. And in the meantime, we keep looking out for more guidance and more clarifications from the supervisory authorities. And Alisa, we very much look forward to the new set of standard contractual clauses, any new privacy framework with the US or other countries, and adequacy decisions. So there's a lot more to happen on the international data transfer level, for sure. Thank you very much.
And if I can take over from here, first of all, I would like to thank again the Digital Week Online organizers for inviting us to organize these session. One of the dangers was that it might have been a cacophony of cats, if you want, having people coming from different entities, even different continents. In reality, I think it was an extremely interesting and useful, above all, session and panel. Evidently, it's been repeated again and again. Many companies are navigating in the dark, not the dark web, but in the dark in terms of what they have to do in order to comply with various regulations. We are, again, I repeat what Gert said, we are very much looking forward for what the institutions are going to do next. But it's very important that we meet all together. And this is one of the mandates of privacy rules, actually. Getting all together around the same table, legal experts from all around the world, cybersecurity experts, representative of the institutions, to debate. I believe that all of us learned a lot from the others. I think it was very nice to hear, in particular from Stephen, the subcontinent where such an enormous amount of data is processed. It's very nice to see how advice is conceived and what is looked for in the local legal framework. So thank you very much, because I think that we have done something useful for the cyber community, which is eventually all of us, our citizens and our fellows wherever they are. Thanks a lot again to the audience, and I invite everyone to visit our website again. You can see it under my face, I said, and to consult with our experts all around the world. This is what Privacy Rules does in 52 jurisdictions so far. Thanks a lot again to Alisa, to Vic in particular. Thank you.
Thank you, and stay safe.
Bye.